with Attorney General Curtis Hill, and that is of abortion. Typically, you don't get this graphic when you're talking about abortion. It just becomes kind of a public policy thing you banter about. Let's talk about dismemberment abortions, which happen from time to time. And as far as I understand it, Indiana does not allow those. And you filed something I saw in the news, a federal document to address this issue. Tell us what you did.
Well, keep in mind that the Attorney General's one of our core responsibilities is to defend the statutes that are enacted by the General Assembly and the executive branch, and we do that. And in this particular area, there have been lots of legislative initiatives regarding abortion and regulation of abortion that are in various stages of litigation. The General Assembly enacted a statute that placed a ban on live dismemberment. What that means is that physicians were able to or are able to extract a fetus, a live fetus, by essentially ripping apart or tearing apart or dismembering the fetus part by part or piece by piece. I believe the General Assembly took the position that that was a brutal and unnecessary process that didn't have anything to do with the decision on whether to proceed with having a child or not having a child, or even in terms of necessary in terms of how to conduct an abortion itself. So they enacted this particular statute, and right away the suit was challenged, and we're holding firm on this, that we're going to go after this, because in this particular situation there are options. And you mentioned, Jim, that it was graphic. I think it's appropriate that we get graphic and get out of just the 30,000-foot policy issue, because we have to look at what's really going on. And the people in Indiana believe that it's appropriate to dismember a live fetus, which would certainly suggest pain and suffering of that fetus. Then they can make that determination through their legislative process. There is, there are procedures that are there, and I don't even like talking about them because they're graphic themselves, in the sense that a physician who conducts abortions can provide a pill or chemical that will destroy the fetus in the womb, and dismemberment as an extractive method can take place at that time. So that.
Well, hold on a second. I don't want to get too graphic either, but just in a general sense, that would, the fetus wouldn't feel anything then when basically the dismemberment was happening. Right. Isn't that the argument on this one? If I remember the legislation going down.
Well, that's not affected. What's affected here is dismemberment of a live fetus. So, you have to get into the nuance of what's occurring here. That's and in that particular situation where the fetus is no longer alive and can no longer feel, then this particular statute that the Indiana General Assembly has approved or passed does not impact that physician's extraction method, including dismemberment. So this only applies to the fetus that's alive.
Wow. All right. Well, I'm glad. Let's just get done with that. Do you mind? That's not. That's not an easy topic. I didn't want to talk. Ryan hands me paper because you got to talk about dismemberment of a fetus, and I'm like, really? On a Wednesday morning?
Let me say this. We can move on, but I think it's important for people to look at this for what it is, and not just fly off at the first glimpse of an emotion and say, well, we do this, we do that. Let's look at what it is and understand what it is, and then determine how we feel about it.
So, all right, let's get to the legal part of this. So, I don't know how long ago, I remember covering a story when this legislator made this debate up. So, it's a law So why do you have to defend it? I mean, are people saying that it's unconstitutional?
Well, anytime it's challenged.
Who's challenging it?
The ACLU.
And why are they challenging it?
Well, they're challenging it because they believe it's an infringement upon the constitutionality of the right to abortion. And so the state engages in a regulation, a regulatory action on the process of procedure of abortion, which is within the state's right under the Constitution. And what we've seen here is almost immediately, and in this particular case, certainly before the ink was dry on the legislation, the ACLU comes in and files a suit and requests an injunction to keep that law from going into effect because they would suggest that it inhibits a woman's right, health, reproduction rights, you name it, across the board. We take the position, and our defense of the position is, no, it's a regulation that has a particularly narrow focus and does not challenge someone's decision to get an abortion and does not even challenge other options. There are options here in which this procedure can take place that doesn't have to go into this particular area. So that's the balancing test. And we defend it. We don't defend it nilly-willy with no action available in front of us. If somebody challenges the action, we defend it. If no one is there to challenge the action, it becomes a law, and I don't have anything to do.
All right, we're talking to Attorney General Curtis Hill. You mind if I go off script here a little bit?
Sure.
How do you feel about the new wave of very strict anti-abortion laws that are coming out of, say, Alabama, Georgia, Ohio even? How do you feel about them?
Well, I think we have to be careful with the approach that's coming out of the states. I think you're seeing a reaction to what happened out of New York and Virginia and some of the other states where those states were aggressively expanding abortion rights. New York to the point where they painted the town pink and celebrated the fact that they were approving abortions of 9-month-old babies. And I think the reaction has been on other states that have a more conservative bend to push the other way. I think those states have to be careful. It's a decision. The Roe v. Wade and subsequent decisions. There's lots of controversy over what they came up with, how they came up with them, and over the years there's been certainly suggestions of groups that have wanted to overturn it. But I think the way that we do it here in Indiana is very effective in the sense that we look at the ability of the state to regulate the procedure, and that's what our General Assembly does. And in this particular case that we just discussed.
So you want a states' right? You want a states' right on this thing?
Well, I think the states have. I think the states have the responsibility and the authority to make that determination, and the better practice is a piece-by-piece process. It's a very Alabama and Georgia are very aggressive in their process. That doesn't necessarily mean that the Supreme Court is going to follow suit. And I think the better approach is to do a step-by-step process until there's a growing concern that perhaps then they revisit the issue of Roe v. Wade. I don't think they're going to revisit it in one fell swoop based on an aggressive play by the state of Alabama.
He's Attorney General Curtis Hill. I guess I was looking for your stance on abortion.
Well, my position on abortion is, I don't mind giving it to you, but my position on abortion is not my job as Attorney General. My job as Attorney General is to defend the statutes, and even if there's a statute that I don't like or I don't prefer. From a personal standpoint, I have no apologies that I'm pro-life, that I feel that abortion is wrong, it's inappropriate, but that's my personal viewpoint. And as a professional lawyer and certainly as Attorney General, I recognize that my job is to defend the statutes, even the statutes that I don't prefer. It certainly makes it more palatable if it's a statute that is on the same side as my personal thoughts, but that's not the driving force in how we do our job.
He is Attorney General Curtis Hill. I appreciate you calling in and going a couple extra.
What you just listened to is a recent flashback on WJOB AM 1230 and FM.